Senator Natasha gives National Assembly clerk till Monday to facilitate her resumption of face legal actions. Wow. Senator Natasha Akpoti-Uduaghan, representing the Kogi Central Senatorial District, has threatened to sue the clerk of the National Assembly. You think the clerk is working on his own instructions? The clerk is working on the instruction of Akpabio, obviously. So why do you want to sue the clerk? Oh, Natasha, this wahala. No be small thing. Because obviously the clerk will not be doing things of his own accord. It's somebody that must be telling him, you must not let her resume. So you want to sue the clerk again? Now what? Oh, they say if he fails to facilitate a resumption of legislative duties by Monday, 15th of September 2025. In a letter to the clerk of the National Assembly through her lawyer, Michael Jonathan Numa, Stan, dated September 10 but received on September 11, with ref number MJN/NA/04/09/25. Senator Akpoti-Uduaghan warned that she would initiate potential proceedings, including committal for contempt, disciplinary action for breach of the Code of Conduct for Public Officers, liability for instigation breach of the peace with potential implications for national security, and any other remedies available under the law. Tower reporters reported on September 9 that the clerk to the National Assembly had told Senator Natasha Akpoti-Uduaghan that her suspension from the Senate could not be addressed until the judicial process was concluded and formally reviewed. In a letter dated September 4, signed by the acting clerk to the National Assembly, Dr. Yahaya Danzaria, it was claimed that the issue of her suspension remains sub judice. We ref NAS/CNA/29/Volume 1/41 entitled Notice of Resumption. The clerk stated, I am directed to acknowledge the receipt of your letter, notifying this office of your intention to resume sitting and other legislative duties in the Senate on the 4th of September 2025, which we claim is the date of expiration of the 6-month suspension imposed on you by the Senate. I am further directed to inform you that your suspension was with effect from Thursday, 6th of March 2025, and draw your attention to the fact that the subject matter of your suspension is presently before the Court of Appeal. Why? Okay, she was the one that appealed the case. Maybe she should withdraw the case from the Court of Appeal, because I don't really understand what they are trying to do to her. The matter therefore remains sub judice, and until the judicial process is concluded, and we know that they are not going to conclude it, and the Senate formally reviews the suspension in the light of the court's pronouncement, no administrative action can be taken by this office to facilitate your resumption. Wow. But Senator Akpoti-Uduaghan, through her lawyer, faulted the clerk's line of argument, advising him to reconsider his untenable stance and comply with the Constitution and extant judicial orders. The Senator's Counsel argues that her suspension expires on September 6, 2025, and that the clerk has no authority to prevent her resumption. The lawyer's letter states, your letter fails to disclose on whose directive you purported to act. You already know now. By assuming powers you do not possess, you have acted ultra vires and placed both yourself personally and your office in contempt of the Constitution and binding judicial orders. The Senator's team claims that the clerk's actions are part of a pattern of judicial defiance by the Senate and that the suspension was unlawful, excessive, and unconstitutional. The letter titled Notice of Resumption, partly read, we are counsels to Senator Natasha Hadiza Akpoti-Uduaghan, the duly elected senator representing the Kogi Central Senatorial District, and on whose behalf we write in response to your above referenced letter. Our client acknowledges receipt of your letter dated 4th of September 2025 with reference number NAS/CNA/29/Volume 1/41, wherein you asserted that the clerk of the National Assembly cannot take any administrative actions towards her planned resumption on the ground that the matter is sub judice, and until a final judicial pronouncement is taken and the Senate formally reviews the suspension in light of the court's pronouncement. With respect, the position conveyed in your letter is untenable. It is either ill-advised or deliberately contrived to deprive our client of the constitutional mandate freely bestowed upon her by the constituents of Kogi Central Senatorial District, and therefore amounts to a politically expedient attempt to subvert the sovereign will of the people. It is imperative to restate that our client's right to resume her parliamentary duties after the expiration of her fixed-term suspension is rooted in the Constitution of the Federal Republic of Nigeria 1999 as amended, and cannot be abridged by administrative fiat or internal Senate maneuverings. Section 68 and 69 of the Constitution circumscribe the limited circumstances under which a senator's seat may be declared vacant. Nowhere does the Constitution empower the clerk or even the Senate itself to, by unilateral action, extinguish the sovereign will of the electorate. The letters our reporters obtained on Thursday read, Senator Otto Dwaga's lawyer insisted that the content of Clark's letter amounts to a convenient invocation and misuse of sub judice rule, tailored to suit the shifting narrative of the Senate leadership. Certain instances, the lawyer recalled that on 3rd day of March 2025, our client, anticipating a suspension as openly professed by the Senate President, Senator Godswill Akpabio, during plenary on the 20th day of February 2025, approached the Federal High Court Abuja Division, challenging inter alia the referral of the events of that day on the floor of the Senate to the Senate Committee on Ethics, Privileges and Code of Conduct for being ultra vires the provision of the Senate Standing Orders 2023. On the 4th day of March 2025, the Federal High Court, Quorum Egwatu J, granted an interim order restraining the Senate and its committee from proceeding with disciplinary action pursuant to the said referral pending when cause would be shown on the return date of the 10th day of March 2025. Upon receipt of the court order, the Senate Standing Committee in question rescheduled its sitting from 11th day of March 2025 to the 5th day of March 2025 in a deliberate attempt to overreach the judicial process. Indeed, the committee acknowledged the existence of the valid order on its report while dismissing her petitions on ground of the sub judice rule, but proceeded with the referral on her alleged misconduct as expressed in its report, particularly at paragraph 7.0, 2 and 3, wherein stated as follows. The other Order 47 of the Senate Standing Orders 2023 as amended, which states that Senate should not receive or deliberate on any matter which actions are pending in any court of law. The petition of Senator Natasha being a matter before a law court of competent jurisdiction, the committee therefore cannot deliberate on the petition, but they did deliberate. And this matter is really a long thing because I don't know what they are trying to do. Now she can't resume. I don't know, because this matter is going to remain in court. We know how these people behave. We know how they behave. It is well. Listeners, don't forget to like, to share, and to subscribe. Thank you for listening. See you some other time. Bye.